We wanted to walk you guys through how we defend simple possession cases specifically. Every time we take a case, especially simple possession or drug related cases, we always go beginning to end. The very beginning, which is the first part of our legal defense strategy, is looking at the stop. In order for the officers to stop you, they have to have reasonable suspicion that a crime is occurring or has happened. They have to have articulable, reasonable facts of a crime. So once we determine whether or not they had reasonable suspicion, we'll order that body cam and we look through the interaction from when they initiated that traffic stop. If we can find that they didn't have a lawful reason to stop you, then the rest of the case can then be suppressed. It's under the doctrine called fruit of the poisonous tree. Now, we can make arguments as to whether or not they had reasonable suspicion to then make that contact with you. If they did have reasonable suspicion and further investigate, then we move on to how they found the drugs. Dakota, do you want to talk about the arguments as far as once they find the drugs?
Yeah, so in order for the officers to extend that traffic stop past, like what Emily talked about, whatever the traffic infraction was, whether it's not stopping at a stop sign completely or whatever it is, in order to extend it past that, they need to have reasonable suspicion, those specific and articulable facts that they can point to that this is why I'm doing what I'm doing. And that kind of leads into how they find the drugs that Emily was talking about in your car. So generally speaking, in order for the police or law enforcement to search your house, your person, anything that you have, they need a search warrant. There are some exceptions to the search warrant requirement. One of those is the automobile exception to the search warrant requirement. That requires them to have what's called probable cause that you are doing something illegal or there is something illegal inside your car. So some of the ways that they can get that probable cause, the first of those is under the plain view doctrine. What the plain view doctrine is that the officer is looking from the outside, somewhere he is lawfully at. He can see from the outside that what he's looking at it's immediately apparent without him manipulating it in any way that it is illegal. A lot of the things we see are things like potentially narcotics laying on a seat, things like drug paraphernalia laying on a seat, things that are immediately apparent that this is what this is. Another way that they can get that probable cause is odor. Odor has had a lot of changes in the case law in the last few years with the CBDs and the legal Delta 8s, Delta 9s. Odor alone is not going to be enough. However, the court is going to use what's called the totality of the circumstances approach in determining whether or not that odor plus things like nervousness and who's not going to be nervous in a traffic stop to give them that probable cause to then go through your car to find the drugs that they're looking for. Another thing that we see more common than not is police get into the car by consent. This requires no probable cause whatsoever. Officers will be at the window and they'll be like, "Hey man, you mind if I look in your car? I'll cut you a break." And what they're doing is they're sweet talking you. So it makes their job a lot easier because they don't have anything. And once you give them that consent to search the car and they search the car and find something, that's when we run into the charges for the simple possession, if it's above 0.5 grams of fentanyl, the felon or the sale and delivery part of that statute. And we run into a lot of issues just because you think you are trying to help yourself by allowing the officer to search your car. We would obviously never advise you to do that. Brandon, do you have any other things about how officers can get into your car or someone's car?
Yeah, so inventory searches is what we see primarily in DUI cases, but it happens even on driving on a suspended license, for example. Your vehicle is going to be towed. Before an officer inventories your vehicle or tows it, they have the right to inventory it to make sure there's nothing in the vehicle that you're then going to complain about and claim that the police stole it and try to sue them. And so they like to search it, have their body cam on so they can see everything that's in the vehicle. When they do that, they oftentimes find things in the vehicle that's going to help them or that they did not expect. So when it's not in plain sight or they don't smell an odor, but then they start searching to make sure that there's nothing in the vehicle, there's not, a laptop or $10,000 in cash, then they find, a few grams of meth or, a pound of marijuana, whatever it might be. But there are specific defenses to the inventory search. Officers have to give you the opportunity to make your own arrangements to move the vehicle before inventory searching the vehicle. It's also important to recognize that officers must be able to establish that the drug is what they believe it is. So oftentimes that requires that they test the drug. Specifically when we talk about marijuana, right? Because there is Delta 8, Delta 10, THCA, and P that look and smell the exact same as marijuana. An officer is not going to be able to establish based on just looking at it and smelling it that it is the illegal version. Someone may even say, I have the illegal marijuana, I bought it from John Smith down the road. Doesn't mean that John Smith didn't sell you the legal version and you thought it was the illegal version, right? So there are a lot of defenses when it comes to the drugs that are found, how they found it, but also establishing it is what the police believe that it is. Which also leads to the discussion of, what is the punishment for simple possession? It's 11 months, 29 days. But there are mandatory minimums like you discussed with meth and fentanyl, a 30-day mandatory minimum, and a simple possession from giving an officer consent, like you mentioned, Dakota. You think an officer says, I'll help you out, just tell me where the meth is in the vehicle. But then they find that it's more than a half a gram, which is a very small amount of meth. They then almost always are going to charge you a sale and delivery, bringing it from 11 months, 29 days to 8 years to 12 years. There are additional defenses available, right? They have to be able to prove that you intend to sell or deliver scales, baggies, large sums of cash, search the contents of your phone, things like that. But oftentimes officers charges the B felony in order to try to then get you to either plead to it or, reduce it to a misdemeanor and have you plead to it. So there's a lot of important, defenses that become available based on those searches. So Andrew, if you want to talk about what are some ways that we try to avoid either the simple possession, sale, let's say the person is guilty and there is literally no defense possible, or there are defenses, what are some ways that we can convince a prosecutor to work with us on a resolution?
Yeah, so I think I got the line from you back when we first met, but one thing that we've brought up to prosecutors before is even if they can convict, why should they want to? Right. So it's one that there's ways for you to be proactive, and there's recommendations that we are almost always going to make on any drug case, whether it be from a simple possession of marijuana all the way up to we're getting into simple possession, potentially even felony for something like methamphetamine, fentanyl, one of the more serious potential punishments. So some of those steps can be like you doing an alcohol and drug assessment, which is a very low intensity, meeting with a drug counselor just to determine if you have any active issues. And these are things that we can show to the prosecutor that you are sober, safe, and being productive, which is generally all that the state of Tennessee, by and large, wants to see out of you. Now, that doesn't necessarily mean they're going to dismiss it, but legal issues like Emily, Dakota, and Brandon talk about, in conjunction with steps that you are taking, can help show a prosecutor why would they want to put forth the effort to convict you? Why does it make sense for you to go to jail for 30 days? Why does it make sense for you to be on probation for 11 months and 29 days rather than, hey, let's have this person submit clean drug screens. Let's have this person do the A&D. Let's have this person get some treatment and then come back and either pass and dismiss this case, dismiss it on cost, dismiss on conditions. There's no shortage of ways that we can try to get creative with prosecutors to get a case dismissed, but it works best when we couple it with legal issues to demonstrate, hey, even if you can, why would you want to?
Absolutely. And another part in representing our clients that I think is extremely important is that we don't just look at, well, how can we defend this case and get the best outcome possible, but also how can we help our client in their personal life? So getting them inpatient or outpatient treatment if it is needed, right? If they get that alcohol and drug assessment and a trained professional, because we're attorneys, we're not trained in substance abuse, but someone trained in substance abuse says you need treatment and you get that treatment. Yes, it should help in your criminal case, potentially in getting the case resolved, but just as importantly, if not more importantly, could prevent you from committing additional crimes in the future because you get the treatment, the help that you need that many people have needed for a long time. Because in many cases, people commit crimes, obviously a drug crime, because they usually have a drug problem, an alcohol problem, or a mental health problem. So getting the resources to fix the underlying problem is usually going to help your criminal case, but more importantly, help you in the long run as well.